Good afternoon. An important concept we have to understand for law and society, particularly at the start of the term with our first project, is definitions of law. Our author for the textbook, Steve Barkan, does a really nice job of giving us a lot of different options or opportunities for reflection in coming up with a definition of law, coming from chapters 2 and 3. So let's take a look. So, first, we could begin by considering various theorists, individual theorists that have thought about law, have come forward with their own um, determinations or definitions of law. And the textbook provides us with a lot of people. I've only identified just a few. So, for instance, if John Austin's definition speaks to you, he says that law is nothing more than the command of the sovereign. So, he has a very strict view that we look to the person in charge. Whatever they say goes. That's law. Because if they're in charge, they have the ability to create the law, they have the ability to enforce it. That's it. Donald Black has a little bit of a different take, looking at law as governmental social control. So it's not just the sovereign, but other aspects of the government as well can be important and can play a role. And then we have the other extreme, where Lon Fuller talks about the inner morality of law. And for Fuller, there are 6 important factors that must be assessed to determine if there is, in fact, law. And if any of those fail, any of the 7 factors, I should say, if any of them fail, then it's not law. And you can take a look at Radcliffe Brown, Hobel, Weber. Each of them has their own unique or distinct a way to define what the law is. They may speak to you and may relate to how you see law working within our community, whether local, state, government, federal government, or in any other particular context. On the other hand, we can look at more formal historical theories, and these perspectives can also give us a way to define what the law means. So we have things like legal formalism or legal positivism. Barkin suggests that they are very similar, and they are, and they look primarily at the idea of whatever the law is, whatever people say it is. Legal positivism means positive law. People make law. Once the law has been made, once it can be enforced, then that's the law. There's not an analysis of good or bad. It is the law because it's been created by us together in whatever community we're in. Natural law contrasts nicely with that, looking at the idea that it's not just what we make. Natural law theorists really look to uh, divine guidance or nature, overarching universal truths or principles that should be true to everyone, regardless of where you are in the world. And those are truly what we should know or call law. The historical perspective is also very interesting, and it's not just one individual, but a group of individuals. This generally was taking place or became the thought of the time in the 19th and early 20th centuries, with people like Sir Henry Maine, Carl von Savigny, Emile Durkheim, and so forth. And so they looked at how communities evolved over time and how the laws changed within the community. And we can continue to look at other named theorists in the textbook, like utilitarian or legal realism, and others, to say that perspective, that major theory, is how I see law really working. The best way for me to describe it is to say it is a function of how the community evolves. So the historical school may be the most influential, and there may be a particular theorist in that school that can speak to you as well. So you can see that the theorists and the theories can work together if they fall into the same family. Um, Lastly, we have some more contemporary theories that are really interesting, and again give us a new opportunity to look at and reflect upon what the law is, how we define it, how it functions. And so the first one, the functionalist versus the conflict perspectives, they come in a pair, and they're an interesting pair. They hold opposite views. So for the functionalist, we're looking at the idea that the major socio-demographic graphic groups of the community are generally in agreement on how things work. And so, if that's true, then they come up with a plan for each person to play their role in the process to make the system, the legal system, function. For the functionalist theory. So each person has a role to play, and they all agree to it, and that's how the process can function. In contrast, the conflict theory argues that these major socio-demographic groups disagree on important legal issues. And so, because there's disagreement, law is used by one group to their advantage to be in control, and they can impose inequality, and that is a problem. So the conflict theory says they don't get along, they don't work well together, and generally one party is controlling it more than others. This really ties into the Marxist perspective because that is the basis for Karl Marx and his perspective on or definition of the law. But even within that arena, there are three different levels or perspectives. We have the instrumentalist view, the structuralist view, and the dialectical view. And the textbook goes into nice detail explaining the three layers or levels of this Marxist perspective, with instrumentalist view being the most absolute. Those in power have the most control, very little that the others can do. Whereas when we step down to the structuralist and then the dialectical, we acknowledge, or some will, adopting that definition, acknowledge that the working class, those not in positions of power, do have some ability to change the law, to effect change, but but still it's within that whole conflict perspective where the table is slightly working against us. It's not a balanced playing field. And then we have three other, I think, well-known theories that Barkan spends a good deal of time talking about: critical legal studies, critical race theory, one that's a topic I think we've heard much about in the past several years in the news in particular, and feminist legal theory. By looking at the details in the chapter reading, we can see how each of these can be a definition or an interpretation of what the law is, how the law works, and how that view or perspective can be our definition for evaluating, again, a particular area, situation, or whatnot. So each of these topics, whether you're looking at a specific individual theorist or a broad theory, can be a great way to start off providing a definition, and that in turn can help you to evaluate the circumstances that are before you. That will play an important role in that first writing assignment. If you have any further questions, reach out to your instructor for more detail. Have a great day.